On 23 January 2023, the Commission sent you a request for submission of the 5-year declaration of assets and personal interests. On 27 January 2023, you submitted your 5-year declaration. The Commission also asked candidates to voluntarily complete and submit an ethics questionnaire. You did not submit a completed questionnaire to the Commission. The Commission sent you 2 rounds of questions on 23 March and 31 March 2023, respectively. You were asked a total number of 15 questions, including 36 subparts, and 16 of these questions included the request for further documentation. According to Article 3, Paragraph 4 of the Evaluation Rules of the Commission, a candidate may not provide information, documents or other materials during the hearing if the Commission requested these earlier and the candidate did not provide them within the time specified, unless, of course, the candidate provides sufficient justification for not providing the information. The Commission notes that last Friday you submitted some additional information and explanations to the Commission after you received the discovery materials by the Secretariat. The Commission has taken note of those documents and will assess at a later stage whether or not to include it in its evaluation. Members of the Commission will now start with asking you questions. It will be Tatiana Raducanu who will start with asking questions. We will try to keep our questions short and to the point, and we ask that your answers be short and to the point as well. Tatiana, you have the floor.
Good afternoon, Madam Cherpec. As for the issue that I would like to address now has to do with the 3 disciplinary procedures that were initiated against you in 2014, 2015 and 2016. I will now start to read the facts and then there will be some questions that I will ask you. So from 2010 to 2016 you worked as a prosecutor in Chișinău Prosecutors Office at the central office. From 2014 to 2016, you were confronted with 3 disciplinary procedures and sanctions related to your work as a prosecutor. On 14 April 2014, a disciplinary procedure was initiated against you. And this ultimately led to a decision of the Disciplinary Board of 29 August 2014, and by that decision you were imposed a disciplinary sanction in the form of a reprimand, as per Article 62, letter B of the law of the Prosecutor's Office. The Disciplinary Board concluded that in the prosecution cases assigned to Prosecutor Mariana Cherpec, she did not practice due diligence, did not put to use the prerogatives offered by law to expedite the investigations, and did not show interest in the quality of the act of justice, and that the missing of deadlines set for examining requests concerning the adoption of solutions set out in the Article 247 of the Code of Criminal Procedure was not due to objective reasons. The Board also underscored that such behavior erodes the trust and respect that justice seekers have towards prosecutors. And by decision of 9 October 2014, the Superior Council of Prosecutors validated the decision taken by the Disciplinary Board. On the 4th of September 2015, a second disciplinary procedure was initiated against you, and it led to a decision of the 2nd of October 2015. And in that case, you were imposed a warning as a disciplinary sanction. And the conclusion of the Board was that you did not fulfill your professional responsibilities pertaining to a prosecutor as set out in Article 52 of the Criminal Procedure Code, and that you did not give concrete instructions to the criminal investigation body, and that you did not respond to the failures of the criminal investigation body despite the powers conferred to opposition, and you did no more than extend perfunctorily the prosecution deadline. On the 26th of November 2015, by decision of the Superior Council of Prosecutors, the Disciplinary Board decision was validated. On the 10th of June 2016, the Disciplinary Board issued its decision in which it concluded that Prosecutor Mariana Cherpec did not discharge adequately her professional responsibilities, thereby violating the law on prosecutors and the Code of Ethics. That is, the failure to discharge one's professional responsibilities, the incorrect or tendentious interpretation or application intentionally or through gross negligence of the legislation. By that decision, you were imposed a reprimand. On the 1st of August 2016, the Superior Council of Prosecutors took note and validated the decision of the disciplinary board. In your written response to questions from the Commission, you confirmed that those 3 procedures did take place in those years and you stated that all 3 were initiated by the then Chief Prosecutor of the Prosecutors Office of Chișinău, Central Office of the Prosecution. You stated that the parties to the trials did not have any issues, claims with regards to how you handled the cases. And you also stated that in your work, you did not allow for any violation, did not violate any human rights and freedoms, and that you did not adopt any illegal or manifestly unfounded decision. You mentioned that after the termination of the mandate of the Chief Prosecutor in 2017, no disciplinary sanctions were applied to you. Quite the contrary, you were seconded to the Prosecutor General's office for about 4 years, which you qualified as a promotion. You indicated that the Chief Prosecutor and you had different views on how to interpret the role and the procedural independence of a prosecutor, and that you provided a different vision than what the Prosecutor's Office system had at that time. You also said that the Chief Prosecutor took a number of measures to influence your decisions, and you rated those actions as harassment against you. You also stated that the Chief Prosecutor at that time had an almost unlimited discretion in the distribution of criminal cases, and that discretion gave the Chief Prosecutor the possibility to punish you for inconvenient subordination. He regularly would withdraw cases from you and would transfer them to other prosecutors. He also implemented a system of unequal distribution. For instance, in February 2014, out of a total of 125 new criminal cases, you were assigned about 30 cases, although in total there were 23 prosecutors in the office. You confirmed that the disciplinary cases related to the fact that there were delays in handling a number of cases, but in your view that was not uncommon given the fact that the workload at the office for all the prosecutors at that time was big. Finally, you mentioned that you did not challenge the decisions of the disciplinary board because you did not trust the objectivity and impartiality of the Superior Council of Prosecutors at that time. Ultimately, the Chief Prosecutor who brought the complaints against you also had the position of member in the Superior Council of Prosecutors, and you also mentioned that you were not heard by the disciplinary board and that your arguments were not verified or taken into account by the board. Now I would like to ask you a number of questions for you to answer. So please confirm that over 2014-2016, 3 disciplinary decisions were taken against you, leading to 2 reprimands and 1 warning. Yes, I confirm. Thank you. Please confirm that all 3 procedures were initiated by the then Chief Prosecutor of the Prosecutors Office, the Central Office. I confirm that in fact 2 procedures were initiated by him. Then I made a correction once I looked into the materials of that procedure where I was concerned, and the disciplinary procedure of 2015 was initiated by the Criminal Prosecution Unit of the Office of the Prosecutor General at the indication of the Deputy Prosecutor General at the time, and I explained what the reasons were. So the one of 2015 was not initiated by this person, but the other, the Chief Prosecutor of Centru, of the Central Prosecutor's Office, was the one who initiated them. But it's just that it's been a while, and I had to go back and remember all those details. It was not a nice experience at all, so I sort of decided to leave them behind. You stated that after the termination of the mandate of this Chief Prosecutor in 2017, no other disciplinary sanctions were brought against you. Is that correct? Correct. He indicated that the Chief Prosecutor and you had different views on how to interpret the role and procedural independence of a prosecutor. Is that correct? Correct. But the Chief Prosecutor was your supervisor, is that correct? Yes, that is correct. Can you explain what those differences of opinion were about? How did this conflict between you and the Chief Prosecutor occur? Well, in fact, there were several moments of disagreement. There was he wouldn't agree with certain decisions that I would make. Regardless, although the Code of Criminal Procedure allowed him, where he believed that certain decisions that I made were ill-founded or illegal, he could have decided on their annulment in part or in totality, but that did not happen. You will not see any decision issued by the Chief Prosecutor with regards to my decision whereby he would claim that they are illegal or unfounded. Still, he had different views when it came to the decisions that I was supposed to take. I have other views, and the solutions that he thought was right was to withdraw the criminal prosecution cases I was working on and to redirect them to other prosecutors who shared his views. And for that reason, we had a number of disagreements, and I was sticking to my guns, and I thought that it was not right. It was actually illegal that cases were being taken away from me. It also had to do with my dignity as a prosecutor. I was working for a long time for a particular criminal case, and when it was already close to decision-making, they would withdraw it away from me, and of course I was not happy about it. So I raised these issues with him, and that was perhaps not taken lightly by the Chief Prosecutor, because never before maybe has he had to be confronted with such situations, but I had the courage, I have to admit, to raise against the system, and that cost me 3 disciplinary procedures. The independence of the prosecutor, the way it is very prettily written on paper and in the law of the prosecutors, that's very nice written there, but in practice you need to fight for it. And were there many cases that were withdrawn from you in that period of time? 2014 to 2016, were there many cases that were redirected from you? At least an approximation. I can't remember very well now, but about 10 or 15 cases were withdrawn from me. If this was not a public interview, I could even give you concrete examples of concrete situations and cases. Now, as this is a public hearing, I cannot disclose that information, not because it's not only about the reputation of the people I would refer to, but it's rather about not inflicting any prejudice to the image of the institution that I represent, because might not have such a good effect or impact on that. So I wouldn't like to prejudice in any way the institution. But what were the reasons that they would take those cases away from you? Was it that he was telling you do things in a certain way, and then you would have a different opinion than that? Well, he wouldn't be straightforward as in you need to make this particular decision. However, out of his words, you could understand that he disagreed with the decision that I was going towards. Because, just so you understand, although I was the one signing off the decision, all those letters related to the sending of the case to court, if there was a decision to file a case away, so they would all go to the archive of the police inspectorate, and they're not signed by the executing prosecutor making the decision, but the chief prosecutor is the one signing it off. And so any case, any decision I would have made, it would anyway go to the chief prosecutor to be looked looked into, although the coordination confirmation procedure would not have to be followed anymore by the hierarchically higher prosecutor, but they will go anyway to the chief prosecutor. Was there any case where you refused to fulfill those instructions to the letter? But there was no instruction given to me in writing. What about orally? Yes, orally, yes. Maybe that instruction was the right one and you didn't implement it, or didn't it happen like that? There weren't cases like that. I mean, I explained that if he believed that if he thought that I made some decision that was not well-founded in his view, then according to his professional responsibilities, being in a hierarchically higher position, he was supposed to verify the decision and to arrive at a decision of his own, to either maintain that, uphold that, or to annul it partially or in totality. But never has this happened. Okay, let's move on to the other question. Given his role, supervisory role, and given the fact that a prosecutor's office is normally organized along hierarchical lines, don't you think that the chief prosecutor had the authority, the remit to give you instructions? Wouldn't a refusal to follow his instructions not amount to an undermining of his authority? Madam Raducanu, let me tell you one more thing about it. I can't remember of one situation where I would go to see him and where he would consult, or I would consult him on something myself as a young prosecutor, as the prosecutor's office. I was not given the necessary support. What is more, this support was rather given by his deputy in charge of criminal prosecution. It's him, his deputy, that I would be able to consult with regards to certain matters where I would feel doubtful. Maybe this might have looked not very professional at the time, but I would consult with his deputy. But as regards the chief prosecutor, I can't remember ever going to see him to talk about legal issues such as how to address a particular act or situation, or if there are certain issues with the law. We've never engaged in such discussions addressing legal matters, that is. Did the chief prosecutor take any measures to influence your decisions, and what actions were these? Do you believe? You mentioned having felt harassed. So could you provide more detail about it? Now, in this public interview, without you being aware of some concrete, specific situations, I think now it would be quite hard to explain myself and to make you understand what were the concrete situations and cases where there were certain attempts to influence me into taking certain decisions. But could you explain it in more general terms, maybe? How was this happening so that we could understand? It was not about directly coming over to me telling me, you need to make this decision that I want. But I would have some discussions now and again with him, and he would hint to certain decisions to be made. As in, he disagreed with some of my views that I had about a decision that I was thinking of making. And given that, as I already explained, given that, well, when he would disagree, those cases would be withdrawn from me, taken away from me, and redirected to a different prosecutor. If, for instance, I thought it was necessary for the case to go to court, but for it to go to court, there had to be this letter accompanying the case file before it goes. I couldn't sign it myself. So it would go through the hands of the chief prosecutor anyway. And if he disagreed, he would take the case away from me and redirect it to a different prosecutor to handle. So it could be like you drew up the letter that it accompanies the case that goes to court, and he was supposed to sign it, but he was not signing it. He would not sign it, but would take the case away and give it to somebody else for a different decision to be made. Yes, he, for instance, would think somebody else about terminating prosecution or about filing away a case, for instance. So in those instances, he would redirect the case. You said that the parties to the trials did not have any claims with regards to how you were handling the cases. Is that correct? Correct. On page 2 of the 2014 decision, if you pay attention to that, there was a decision of the 2014 decision of the disciplinary board. It says that on the day of the internal performance evaluation 4 complaints from a number of citizens were found on the desk of Prosecutor Cherpec, and that those complaints were sent via certain members of the parliament. What were those complaints about? If you look at the rules of the Code of Criminal Procedure referred to in the decision, it's a 2014. Well, it's actually 248, the provisions that refers to. That has to do with the requests filed during the criminal prosecution, so there were not actually complaints. If there were complaints with regards to the actions undertaken by the prosecutors, and those complaints would have been drafted according to the Criminal Procedure Code according to a different article, and they would have been filed with a hierarchically higher prosecutor who would have looked into my work as the leading prosecutor in a case. And what is more, in the content of this decision, in the text of it, you've also read it that as part that during the control, during that inspection on the desk of the prosecutor, 4 complaints were found. And at the very outset, I'd like to start by saying that against me, illegal searches were carried out at my work desk. So these 2014 disciplinary procedure and the 2016 disciplinary procedure at the indication of the chief prosecutor of the Prosecutors Office at that time and his deputy, they carried out searches at my desk, and they looked into absolutely all the materials and cases everywhere, the safe box on my desk, everywhere I would keep my papers, although the law on prosecutors guarantees the inviolability of my desk as a prosecutor, and the searches of the desk of a prosecutor is to be carried out only as set out by the law and only if there's a warrant issued by a court, and that was not there in my case. And I believe that that is abuse against myself. Did you challenge anywhere those searches conducted at your workplace? I did not challenge it. And I've already also explained in the written communication that we had. I said that because I didn't trust the objectivity and impartiality of the institutions I was supposed to take the challenge to, considering the authority of the chief prosecutor at that time. Initially, he was a member of the Superior Council of Prosecutors, and he was a member of the qualification board, and therefore I know also out of discussion with other members of the disciplinary board, I know that the attempts were made to influence the decisions that concerned me. So those arguments that we had, those professional arguments that we had, he took them to the heart, he took them personally, and he insisted a lot on holding me disciplinarily responsible. And for that reason, I didn't even take that up to other institutions. But when did those searches happen? Was it during 2014, 15, 16, over those 3 years? Well, as regards the disciplinary procedures of 2014, in February 2014, that's when this referral is made to those alleged violations of those were searches done, and then in 2016 there were searches again of my workplace. On page 2 of the 2016 decision, it says that on the 18th of March, you received a complaint from a citizen, so that is for the Central District Prosecutor's Office. There was a complaint from a citizen X regarding the delays in the criminal prosecution of a sad case. And on that same page, it says that contrary to the provisions of Article 244-247 of the Code of Criminal Procedure, Prosecutor Cherpec did not examine the complaints of the stakeholder of the party concerned in that case, and in order to camouflage her inaction, she formally issued a document in the form of a response, an answer. What is this response about? That contains, it says, untruthful information. What was that about? In this case, too, it was not a complaint. There were certain motions and requests that are being filed during prosecution. For instance, the parties inquire into the progress of the criminal prosecution, what stage is the case at, for instance, and I provided that answer, that response, and I informed them. If that was a complaint, I already explained it previously, they were supposed to file that as per Article 299 of the Code of Criminal Procedure, and the chief prosecutor was supposed to look into them as higher position. But in this particular case, it is not a complaint per se, not a complaint about the action or inaction of the prosecutor. Those were certain requests, inquiries, solicitations in connection to the criminal prosecution in that particular case. But in the decision, the decision says that that answer never left the secretariat of the prosecutor's office. How can you explain that? There are situations where sometimes the parties to a case, they would come to my office, they sign to confirm that they received it, and I just give it to them, and it's not necessary to bureaucratize everything. Often we do it through emails. We send the answers to the parties or to the lawyers, to the attorneys through emails as well. In these disciplinary procedures, they highlight there's been delays in settling a number of cases. How can I explain that? My explanation is, as I also mentioned in our written correspondence, there was an uneven distribution of the workload. In one of the decisions of the disciplinary board, they referred to the fact that following an analysis they found that my workload, they said, was not bigger than the workload of other prosecutors. But I would like to say there's been no analysis whatsoever, not even to this time. There was no analysis into the workload distributed to the prosecutors across prosecutor's office. So that's why for me it is inexplicable. How did they even reach such a conclusion that they did? Because considering there was no analysis into the workload of the central prosecutor's office, considering the number of prosecutors, number of criminal cases, and also one would need to consider the complexity of a case. So in addition to the fact that there were more than 60 cases underway that I was in charge of, there were also court hearings I had to go to, because now there's also this, now that we have specialization of prosecutors, but at the time, a prosecutor would take a case from the beginning and follow it through till the very end until a sentence is pronounced. So we had to be in charge of cases. There were petitions needed to respond to. We had to go to court, and I was also specializing in general supervision. So I am aware, according to certain indications or some order that it was from the General Prosecutor's Office, I know the prosecutors who would be distributed, who were assigned to general supervision, they were supposed to also be given then a smaller number of criminal cases. But in my case, they would not observe this requirement. In addition to criminal cases, I would also do inspection in mayoralties, in health facilities, and so on and so forth. And I would have to also provide some response to that, to put together something there as well. The law on prosecutors has provided for these duties for prosecutors until August 2016, and in August 2016, at the time, the provisions of the law number 3 entered into force.
So it was just up to the Prosecutor General's discretion how many files, how many cases go to which prosecutors. It wasn't random distribution. No, this is happening now as well. It depends on the good faith of the chief prosecutor. For instance, we are just left at his discretion how many cases to how many prosecutors are distributed. Moreover, not even until now in the prosecutorial system, there is a mechanism to check, to monitor the way how chief prosecutors distribute the amount of work to the non-managerial prosecutors. And under such circumstances, the chief prosecutor has all the discretion. And as it happened in my cases, they used the authority of their position and gave me a large amount of work, which made me violate certain deadlines in examination of cases. And I made reference to the number of criminal proceedings distributed to me in February 2014, when this disciplinary action started against me. I provided the disciplinary board with that. I did not know that you don't have it. So during that disciplinary procedure, I provided them an abstract from the register of cases received from Centru Police Inspectorate, where I proved that out of 125 criminal cases received with a refusal to start criminal investigation, 23 out of 23 prosecutors who are working now, I was given around 30 criminal cases of that number, and I had like 5 days deadlines. So besides these criminal cases I said before, I also had court hearings, other cases I was working on, petitions that I had to examine. So in the decision of 2014, there is a reference to 2 or 3 criminal cases without taking into account that before that I examined more than 20 criminal cases. So my arguments were entirely ignored. Moreover, the disciplinary board is obliged to find when they sanction a prosecutor, they are obliged to mention the causes and the circumstances that led to such violations or omissions. But if you look into all these decisions of a disciplinary board, you will never see, well, you will not see any mention to the reasons, to the conditions that led to such so-called omissions. Indeed, in the decision of 2016, it is mentioned that you had a case in your safe for more than 2 years, that there was delay in several cases. So, well, why did it happen like that? About that case, I can tell you it is a complex one. It was being carried out by me. I received it from another prosecutor who got transferred to the General Prosecutor's Office. It was about allegedly illegal occupation of 30 land plots from Codru town in Chișinău municipality. It was a huge amount of work because these land plots were not, did not even have cadastral plans. They did not have any cadastral numbers assigned. So I had to include in this entire process of investigation both professionals from cadastre and from the some technical works institute, and it took time for all cadastral works to take place. And if you pay attention, you can see that when this disciplinary procedure started, that case was withdrawn from my procedure and given not to another prosecutor, but it was taken to the General Prosecutor's Office, to the unit of prosecution on exceptional cases. And I don't know, can you call that exceptional circumstances case? I had not heard anything about that case ever since. And I can tell you that before they took it from me, I had lots of requests from many people, like in writing, whereby they were asking for information about this case. And every time I was explaining that taking into account confidentiality of prosecution, they cannot get a lot of information. So in the end, it was easiest to make a prosecutor guilty for causing delay in prosecution, for that to be a reason to withdraw that case from that prosecutor. And this is what happened. This case was taken from my procedure. But you also mentioned your expertise. Yes, I requested an expert review. Is that because they invoked that it took me 3 months to ask for some forensic financial accounting and like urbanism or territory cadastral techniques. We understand as lawyers that for an expert review you need all the documentation, you need to consult other professionals to write the correct questions in order to obtain a complete, objective and accurate expert review. That's why it took me more time to prepare all those materials in order to... So this is a case about land plots, but other files that you had there, were there any other files in your safe or only this one? It was this one and I think one more because an internal decision was not taken. What was the second one about? It was quashed. Was it? Yes. Meaning that the people, if I remember that correctly, the people were taken out of prosecution proceedings earlier. Then it was sent to the police inspectorate to carry out additional investigations, and then they came up with a suggestion to quash the case, and I violated the 15-day allegedly violated this 15-day term to make the decision, and as far as I remember, the decision was to quash that case. Okay, you declared you were not heard by the disciplinary board. I did not declare I was not heard. I declared that my arguments were not taken into account by the board. I was heard. Yeah, even though in the decision they mention some minor aspects, let's say. They did not express my entire statement. Well, in your decision, it said that you admitted your failures, partially you admitted your guilt, partially in the meeting and explained the violations. Yes, I admitted, because indeed there were some violations of the deadlines, that prosecution took longer time, and I explained what the reasons were. But the fact that the disciplinary board did not take into account everything that I stated is another thing. But you were invited to the disciplinary board, and we heard. How long was the hearing? Well, it's a long time after that, so I don't remember how long, like maybe 5 or 10 minutes, not more. Do you believe the hearing to be fair, or what do you think about it? My opinion is that the members of the disciplinary board had an opinion before I was heard. So they were already inclined or decided on what kind of a decision they were going to make, even during the last procedures, because it's about exactly the same disciplinary board. They did the same membership because it did not change. Even in the last time when I was coming in, they were saying, Madam Cherpec, we already know you. I was coming there as a renowned person. It was a point of fun for them. Even though they know, as I mentioned in our written communication, they knew about the issues that existed. You did not challenge the decisions. And you said that happened because you did not trust the objectivity and impartiality of the SCP at that time. Is that right? Yes, it is right. I knew from the beginning the solution that they would issue, that I was not going to be heard or listened to, she means, and in order not to be put under this pressure, and for my emotional and psychological well-being, I decided not to challenge because it wasn't the right time. And at least that time, your boss was a member of the SCP. For some time, he was a member of the SCP, but in 2015-2016, he was a member of the qualification board. At the moment when I gave you the written answers, from what I remembered, he was a member of the SCP. So he was a member only in 2014 in SCP. Is that right? Yes. And 2015 and 2016, during that time, he was a member of a qualification board. And one more thing, if they had some objection about my professionalism, they had the competence to send me to an extraordinary assessment, professional assessment, but they never did it. Even the prosecutor that I mentioned, in discussions with other people, he always said I was a professional, but despite that, there were discrepancies happened between us, and this is what it led to. Do you know, in 2014, was he part of a meeting that validated the decision to issue you a disciplinary sanction? I don't know. You don't know, okay. Because they are validated in the absence of prosecutors. So his name is not, well, the commission found that his name is not in the decision, so you don't know any other information. No, I don't know. Have there been any reasons for which you did not trust the independence and impartiality of the disciplinary board? Yes, there were. Because I knew that the chief prosecutor at that time was friends with, or even sort of relatives with members of SCP. What about the disciplinary board? In the disciplinary board as well. You mentioned you tried to prove the disciplinary board the existence of an unfair distribution of cases. What was the answer? Did you tell the board about it? Of course I told them, but if you can take a look at the decision, nothing is mentioned there about it. So you submitted them in a document, or did you say them verbally? I provided them with statements from the Register of Chancellery, how the amount of work is being assigned, and this was not taken into account. The decision doesn't say that you provided any information about it. This proves that they did not take into account the arguments, the documents that I submitted to them. They strictly followed the arguments or the reasoning mentioned in the report of the chief prosecutor. Do you have anything else to add regarding this? No? Nothing to add. Microphone, please.
Yeah, I have a few additional questions on this. Were there other colleagues in your office that had similar or comparable issues with the chief prosecutor at the time? Were there other frictions within the office?
Yes, some prosecutors. Some prosecutors had similar discrepancies. I just want to raise another topic. Usually, when a prosecutor has issues, the so-called issues that I had, the other colleagues, well, that's probably how the system, they don't have enough courage to support each other. In the office, of course, they say that, oh, indeed, this was a wrong decision about you. But in relationship to the chief prosecutors, in order to avoid problems like I had, they have a totally different attitude. And for these reasons, I don't know, maybe for the lack of courage, I did not have support coming from my colleagues, because maybe they were afraid. Some of them said, I have children at home, or I have loans to pay out, and they did not want to go through the same situation that I had. So I had enough courage to oppose to certain influence. I had to bear the consequences of what happened, and now I have to explain the Commission what were the reasons why I was sanctioned.
And another question that I have is, was there within the prosecutor's office a sort of a centralized system by which you could see when cases got started, how long the cases were? Could you sort of check whether there were any cases that were taking too long? Any IT system or something like that that would assist you in that respect?
At that time, no such system existed. Currently, well, since 2017, in the prosecutorial system, an automated information system, e-file, e-dosar, was implemented, and now this thing you're asking about can be seen. When I was sanctioned with these disciplinary issues, such a system did not exist at the prosecutor's office. There were only registers to record criminal files, activity reports, and that's all.
And when you were invited to come to a meeting of the disciplinary board, you said those meetings or those hearings took 5 or 10 minutes. Were you provided information in advance about what the questions were? Did you have an opportunity to write or to provide written comments in advance or afterwards or something like that?
No, no such questions were provided beforehand. I defended myself the best way I could. As I said, I provided statements from registers, answers to the questions that the members had, and that's all. Meaning I did not have a period of time to prepare. No, I gave explanations about the circumstances that were invoked, and the members of the board in like 5 or 10 minutes issued the decision and informed me about it, and that's all.
I have no further questions, but Nadia, please go ahead.
Thank you for your answers. I have some questions. I would like to clarify. You mentioned that you submitted the disciplinary board statements. Do you happen to have those documents? Or maybe you expressed your position in writing on all those cases. Maybe you could share them with the Commission. Actually, I thought that besides the decisions of a disciplinary board, you also have a procedural materials of it. That's why I did not make the appropriate request to the prosecutor's inspection to receive these documents, but I submitted them in one copy only. Currently, I don't have them. I mean, I can only make a request towards prosecutorial inspection and then submit them to you. Okay, thank you. The second question. Well, in case of judges, the procedure is that before they are heard in the disciplinary board, the judge is given the right of access to all materials gathered by the judicial inspection. And then a written opinion is asked. So, as I understand, there is no such system in the prosecutorial system. No, it doesn't. So you did not see the materials and you did not provide a written opinion of yours on this. Okay, thank you. And the last question, or maybe there will be others. You got transferred to the General Prosecutor's Office in 2016, right? No, I worked in Central Prosecutor's Office until November 1st, 2017, and then I was transferred to Botanica office, where I worked for 1.5 years, and in since July 2019 until February this year, I worked at the General Prosecutor's Office, and currently I am back to Chișinău Prosecutor's Office, and I am not a communication officer anymore. I am back to the position of prosecutor in Central Office of Chișinău Municipality Prosecutor's Office. So after the last procedure of 2016, did you have any other disciplinary proceedings or, I don't know, some warnings or about your work? Or regarding your delays, not in Botanica office, not just the other way around. If you check with Botanica office, or I could provide you that information. For 2018, I had the best activity or performance indicators out of all prosecutors working for the territorial office. And I never had similar discrepancies with other chief prosecutors. It happened only when I was working in the Central office, and I explained you why that happened. Thank you. I have no further questions.
Victoria, go ahead. Yeah.
A couple, thank you. I may be a little confused. When you went to the disciplinary board hearing, had you had any communications from the board or from anybody about the disciplinary proceeding?
Could you please explain what kind of communication you mean? Like, was I informed that I have to come, or is this?
Whether you were told what was their concern, what type of allegations they were investigating? Were you ever contacted for any kind of response about the delay issues or anything else about the cases before going to the hearing?
I wrote a written explanation because currently we have now prosecutor's inspection that investigates actions or alleged disciplinary actions against prosecutors. But at that time, in 2014 until 2016, it was internal security unit of a prosecutor general's office that was carrying out all investigations, and they were sending materials to the disciplinary board. And within that, into that internal security unit, I provided my explanations and documents that were explaining that I was not guilty of what they were incriminating me to be.
my question is, what prompted you to know what materials to provide for the hearing or to provide to that inspectorate? Were you interviewed or somehow told about the issues that were under consideration?
I knew what was requested, what was taken from my office during the searches. I knew what cases were under my proceedings at that time, and I had that in relation to those cases, I was supposed to provide explanations, and so I did. I provided the appropriate explanations.
Okay, as to the chief prosecutor, and I understand that you left that office in 2017. How long did the chief prosecutor stay at the office, and do you know where the chief prosecutor is today?
He actually left before me because his chief prosecutor mandate expired, and a new chief prosecutor came to the Centru office. He worked for some time, one mandate, in a territorial prosecutor's office. Currently, in the same prosecutor, he's having an acting chief position. So, meaning that he's a chief prosecutor, but not in Centru office, but in a district, like territorial in the country prosecutor's office.
Yeah, no, please go ahead.
I have a question concerning the hearing. You mentioned that it took them 10 to 15 minutes to listen to you, and if I understand correctly, they immediately delivered decision. I just want to understand, did it happen on the spot, or were you, what was the procedure of delivering the decision? Was it on the same day, or how it happened?
That is the procedure. As I said, they heard me for 5 or 10 minutes. I left the room. Another 5 or 10 minutes. I came back, and they told me the solution.
So it was oral decision that was shared with you, and then after some time you were given the written decision. Is it correct?
Yes, that is right. They informed me verbally, and then I received a written decision.
I also have a question concerning the cases that were reassigned from you to another prosecutors. I understand that you cannot disclose the facts of those cases, but in order to understand, were they high-profile cases or just ordinary cases?
I think they were regular cases because territorial offices don't have like high-profile cases. A few of them are very complex, like the one with 30 land plots that needs a longer investigation. Usually, they're quite simple cases, not high-profile cases.
If there are no more questions to the candidate, then yeah, Victoria, yeah.
Oh, I had another question on another matter.
Yeah, sure, go ahead, yeah.
Okay. Briefly, I'd like to ask you about a subject that you were asked about, I think in round 2 of the questions, which had to do with not filing a declaration of assets and income in 2010 and 2011. And I believe that you explained that you didn't believe that the law on filing statements required all prosecutors to file declarations, just chief prosecutors and their deputies. Is that correct?
Actually, I revised and provided an additional explanation because in the first round of questions, I explained it this way. because the person who is assigned in the HR unit at the General Prosecutor's Office, who is responsible for keeping the register of declarations of assets, she told me that before 2012, state declarations were filed only by chief prosecutors, and she showed me the register of these declarations of assets. So the record keeping started in 2012, not before. And I explained the Commission that from the communication with representatives of the Integrity Authority, starting with March 2012, when the National Integrity Commission started to work, in the next year, all prosecutors filed their first declaration of assets and personal interests. And I did the same as the other prosecutors, non-managerial executors. I know from discussions with some chief prosecutors that they filed such declarations to a control commission, but non-managerial prosecutors for the years 2010 and 2011 did not file. I did not say I was not obliged. There was no authority assigned responsible to check declarations of assets of prosecutors at that time.
And when I think you said the Human Relations officer told you that only chief prosecutors had filed declarations in 2010 and 2011, was that something you were told at the time, or that you were told, for example, during the evaluation when we were asking questions about it?
During the evaluation, when you were asking questions, the HR person told me that.
So quickly, I'd like to just ask you about a provision of the Prosecutors Ethics Code in 2007 at subsection 5 that says, in the performance of his or her duties, the prosecutor must also, in subpart C, is present in accordance with the law a declaration regarding income and property upon being included in the prosecutor's office bodies, subsequently every year, and upon dismissal. Can you reconcile that with your understanding of what the law required?
You may notice that the Code of Ethics that you make reference to is of 2017. Which means the declarations that you're asking me about are of 2010, 2011. I'm not saying I was not obliged to file them, but at that time, in 2010, when I was hired on December 3rd, 2010, and then in 2011, there was not a competent authority in Moldova that would receive these declarations and check them. And for this reason, we, prosecutors, did not file them. I am not the only prosecutor who did not file that declaration. If you check the website of the National Integrity Authority, all prosecutors started to file declarations in 2013 for the year 2012.
I just want to clarify the Code of Ethics that I was referring to was the 2007, not 2017. Just for correction. Is there anything else you'd like to add on that subject?
With regards to this particular subject, I have nothing else to add.
Colleagues, any questions further for the candidate? Then, if that is not the case, then I would like now to give you the opportunity to make a brief closing statement to the Commission. So please go ahead.
Esteemed members of the Evaluation Commission, I would like to thank you for all the questions you've drawn up and asked me. Thank you for the patience listening to my answers to the questions. I trust that the Commission will be objective in assessing all the circumstances concerning myself, and that the Commission will ensure equidistant and fair appreciation. I admit that throughout my work as regards these disciplinary actions concerning myself, well, I would not like to put all the blame on the institution or on the chief prosecutor. I admit, recognize that there were certain inadvertent omissions. But considering their level of severity, I'd actually like to say that I don't think that they are severe in their nature, not gross in their nature, such as to altogether determine or lead to a conclusion that I would lack ethical integrity as a professional. What is more, I would like to underscore and bring to the attention of the Commission that the disciplinary procedures I was concerned in, that they happened about 7 years ago. So since 2016 onwards, I was never concerned again in a disciplinary procedure, and I was never imposed a disciplinary sanction on. Quite to the contrary, as I mentioned, my work was appreciated, and I was also further incentivized for the work that I was able to perform. I would also like the Evaluation Commission to pay attention to the fact that the matters that were raised in all those disciplinary procedures do not show or point to the fact that that my actions would have led to certain severe consequences. So I was never blamed for having issued any illegal decisions, unfounded decisions, or that would have been surrounded by some serious doubt. What is more, there is no decision with regards to me saying that I would have violated the human rights and fundamental freedoms, which is very important because observing human rights and fundamental freedoms are a priority in my work as a prosecutor. And at the end of this hearing, to be honest, I'd like to say that this evaluation procedure, it was a test for myself as a professional, and I decided, well aware, to get involved in this process because I really want things to change in the system of the prosecution. And I believe that the experience that I have as a prosecutor for 12 years of work, I think that this allows me to be able to contribute to this change. And what is more, I hope and I would like to believe that at long last in our country, prosecutors that show integrity, that are honest, will finally be appreciated. This is what I wanted to say to the Commission members at the end of this hearing. I would like to thank you very much, and I would like to wish the best of luck to all the other candidates, and have a nice rest of the day. Thank you.
Thank you very much. And with that, we come to the end of the hearing. I thank you again for your submissions in writing, but also the answers to the Commission today. The Commission will now withdraw for deliberations, and as much as possible, the Commission will strive at delivering a decision within a month after the date of the hearing. Thanks again for your participation, and I hereby declare the hearing closed. Thank you.
I would like to thank you too.